Welcome back to the Law and Crime Network. I'm Heather Hansen, and I have two fabulous guests for you during this lunch break in the McIver case. First, here in the studio, I have Imran Ansari. He is a defense attorney, criminal defense attorney, former prosecutor, currently doing some civil work, sort of running the gamut. Welcome, Imran.
Thank you. It's very happy to be here.
Very good to have you. We also have via Skype one of our old favorites, Andell Brown, who's a criminal defense attorney. Hi, Andell. Guys, do we have sound for Andell? I see him, but I don't hear him.
Hi, Heather. How are you doing today?
I am great. I'm so excited to be joined by you two gentlemen. And the first thing that I want to talk about is the testimony we just heard from the surgeon who tried to save Diane's life. The testimony itself, arguably, was meant to establish the cause of death, the trajectory of the bullet, the fact that the surgeons did everything that they could to save her. And all of that testimony, I want to start with you, Imran, that's the type of thing you expect in these cases, right?
That's correct. So, in a homicide case or a manslaughter case where there's a death involved, you expect to hear the treating physician that first treated the alleged victim to testify on the stand. Most of the times they discuss the treatment they rendered to the patient. They discuss some of the forensic issues that may be at play. That would be trajectory of the bullet, the entry and the exit wound of that bullet. And that's the common testimony that you expect to hear from a physician on the stand in a case like this.
Right. And then here, though, Andell, one of the things that maybe you don't expect to hear is the specifics of the statement that Tex McIver made to the other doctor who came into the room to tell Tex that his wife had passed away. That other doctor was, we just heard, Dr. Syed, and he said something to the effect to Dr. Syed, like, "Don't tell me when to sit down, boy." And that testimony was allowed after some argument between the lawyers. Were you surprised with that, Andell?
I wasn't particularly surprised, and to be honest, Heather, after hearing the facts of these cases that have played out in trial, there's not a whole lot you find surprising. Because there's always been a lot of tangles and twists and turns. When I heard that testimony, I asked myself the same question you probably did. Is the prejudicial value outweighed by how probative this statement is? Mm-hmm. Whether or not the jury's going to look at what Tex said and make any preconceived notions about him or his innocence or his guilt just based off of those statements. I didn't think so, and the jury didn't really seem to be too concerned with it. I thought the prosecution was hoping to use it to show that Tex had a particular state of mind at that point in time, that he really was more or less not involved as one should be, or not showing grief as one should when their partner, their life partner, their wife, the love of their life, they've just been told that she has passed away.
Yeah, and so there's a lot that you said that just there, Andell, that I sort of want to unpack. And the first thing is, for the judge to decide this issue, there's a motion to preclude this testimony, and he has to decide whether or not it's relevant. And so to do that, as you said, Andell, he has to weigh the probative value with the prejudicial value. For me, I don't see what the probative value was of that. So I feel as though it was, I don't think it's reversible error. I don't think this case would go back on appeal on that, but I was surprised that the judge found that there was enough of a probative value of that statement that overcame the prejudicial issue, where it really makes Tex out to be arguably a bigot. I was surprised that the judge let it in. Although, as you said, Andell, in this case, very little surprises me, and it does feel as though, to me anyway, and I'd like to hear what both of you think about this, the judge is maybe erring on his rulings on the side of the prosecution. Do you feel that way, Andell?
Well, I think the judge is erring on the side of letting the jurors hear the evidence and make a decision for themselves. He'd rather allow more in than be too restrictive, too conservative on what he lets in. You want the jurors to have the relevant information so that they can make a proper and lawful decision. And
that's a really good point, Imran, because it's, letting in almost everything. Oftentimes when I'm trying a case, I prefer that. Let it all in. Let's let the jury decide. Right. And the great thing here, you and I were commenting on this as we were watching, the jurors' questions weren't focused on that piece that maybe was prejudicial. Right. They were focused on the most probative, the most relevant, the most important part. Do you think jurors in general tend to get it?
Yeah, I think so. As a trial attorney, sometimes we underestimate the jurors, right? So here you heard testimony from the doctor elicited from the prosecution regarding McIver's sort of demeanor, the way he reacted to the news that his wife had died. And then you heard from the defense, questions about, well, wouldn't it be expected that there may be a different reaction from someone who just found out in a tragedy that it could be an accident, could be intentional, but they shot their wife. So that is a shocking sort of piece of information. And you heard from the defense. They elicited testimony that would go to say and build an argument that they could really hit home at summation. Well, listen, this individual just found out his wife died. Not everyone breaks down crying. Some people take these sort of tragic, sad news in different ways. But then you got to the jurors' questions, right? And I think that's the best snapshot for these attorneys to see the state of mind of not the defendant, but the jurors in this case. You saw the questions from the jurors. They were specific, and they actually went to the treatment, to the really questions that may be arguably more relevant in this case, rather than some of the ancillary issues or testimony that the prosecution wanted to get in when they got over that motion in limine.
So I want to ask both of you, and you can answer at the same time. Do you guys practice in jurisdictions where the jurors get to ask questions? I don't.
No, I don't.
It's always fascinating to me. I think that if I were trying a case in one of those jurisdictions, I would be reading way too much into the jurors' questions and trying to sort of adjust my case according to those questions. The questions we heard today from the jury, I thought showed that they're very focused. They're focused on the evidence, and they're looking to see, the issues that are most important. Andell, you pointed out that this judge has been allowing in, everything and letting the jury sort of see everything. And this morning we saw that he's going to allow the jurors to do some sort of a site visit with the SUV. I'll start with you, Andell. What do you think about that?
Well, I think the more the merrier in a situation like this. I don't think the defense is really going to have much of a contention about it, and I don't think it hurts the prosecution. I think we want the jurors to kind of see the quarters, especially on the defense side. When you look at the particular seats from that vehicle, I believe it's a Ford Expedition, you see all the mechanics and other things that they are on the back of the seat. You think if Tex was some mastermind that was plotting to kill his wife through this means, there would have been a lot better ways to do it than to fire a blind shot from, in the back of a seat that has so many other things in there that could divert the bullet. And we don't know that, shooting someone in that area is necessarily fatal. So I think the defense is going to try to use that to show what exactly happened and to show that it's unlikely that if Tex was plotting to kill his wife, he would have done it this way. On the other hand, the prosecution is going to use it to show that Tex made many statements that were not in line with the physical evidence. They're going to show that the statements and the other things he tried to do with the other witnesses that were involved kind of give him, it makes him look guilty. It gives him a reason to lie because he did something wrong. That's where they're coming from.
Yeah, the other piece of evidence that the judge is going to allow the jury to see, at least according to what we've heard thus far, is the gun. So I want to now show you testimony of a firearms expert who testified in this case. And then when we come back, guys, I want to talk to you about the jury actually handling the gun, the amount of guns the jury has seen in this case, and how that might impact their decision. So first, this firearm expert who testified week before last.
A firearms expert took the stand in the murder trial of prominent Atlanta attorney Claude Tex McIver. McIver claims the shooting death of his wife, Diane McIver, was an accident. The defense contends the gun accidentally fired while McIver handled it in the back seat of the SUV he and his wife were riding in, striking and fatally injuring Diane. The prosecution contends it was no accident and the defendant had financial motives for the killing. Firearms expert Zachary Weitzel took the stand and demonstrated the difference between single action and double action.
There's a single action notch on the bottom of the hammer, and then there is a corresponding ledge, so to speak, on the top of the trigger. It's just a very slight movement. Were you able to see? So with double action, you see that the trigger is now set further back. Okay, so from there, I would have to pull the trigger all the way. So about to there is as far as I can stage it without the hammer falling. But then from this, it's almost the same distance as the single action, but it would have to travel this full distance to fire.
And called into question the defendant's story of accidentally shooting his wife while handling the gun.
This firearm, if I just hold it in my hands like this, will it just go off?
No.
If I sit down with it and hold it down here in my lap, will it just go off?
No.
If I handle it like this in any way, will it just go off?
No.
What will make this firearm go off?
Something would have to act on the trigger.
And when you say something has to act on the trigger, what do you mean?
I mean, the trigger has to be pulled rearward.
But on cross-examination, the defense attorney made it clear that firearms can be unintentionally discharged.
As opposed to an accidental discharge, there is something that you know of that's called an unintentional discharge, correct?
Right.
And an unintentional discharge means that one can put pressure on the trigger unintentionally and that the weapon can discharge, correct?
Right.
For a number of reasons, including being startled, correct?
Right.
And again, this weapon, as well as any other weapons, can be unintentionally discharged, correct?
It can be.
Did McIver intentionally shoot his wife for financial gain, or was this just an unfortunate accident? I'm Rachel Stockman for Law and Crime.
All right, ladies and gentlemen, here's the thing that's so interesting about this. And Andell and Imran, I want to talk to you about this. The difference between an accidental discharge and a deliberate discharge is 10 pounds of pressure. That's what we've heard from some of the guests we've had here at the Law and Crime Network about the specifics of this gun. So ultimately, Imran, do you think that this case comes down to 10 pounds of pressure?
Well, I think it was a pretty compelling testimony from the firearms expert that we heard from. He described the difference between a single action and a double action, but in this case, there's really no way to tell whether it was in single action mode or double action mode when that gun went off. But it's telling that that amount of pressure would be needed to pull that trigger and fire that gun. If you think about it, if it was an accidental shooting, it would have to be significant force on that trigger to set that gun off. So that testimony sets up the prosecution for a compelling argument that this was not accidental, this was a significant force on this trigger, and that McIver pulled that trigger.
But Andell, don't you think that the fact that this expert couldn't say it wasn't an accident, if the burden of proof is beyond a reasonable doubt, how did you feel about that testimony for each side of this case?
I think if you're on the prosecution side, that should concern you, the fact that you can't determine whether or not the gun was in single or double action use, because there's a big difference between 2 pounds of pressure and 12 pounds of pressure. It's a significant difference to the feel, and I think it would definitely make an impression on the jury about how intentional or unintentional this crime was. The fact that they cannot make that determination as a prosecution, as a defense lawyer, one of the things I always tell the jury is www.ask the state. They have to answer those questions. If they can't answer those questions, your verdict has to be not guilty, because they came in here, they made a promise that they're going to prove their case beyond a reasonable doubt. If they can't fulfill that promise, then it has to be not guilty. That's the only lawful answer. And if they can't answer the question about exactly how much pressure it would have taken for that gun to go off, then they can't say whether or not it was an accident.
Yeah, and so many times here at the Law and Crime Network, we see not guilty verdicts, and a lot of people are shocked with them. But beyond a reasonable doubt is a serious level to overcome. We had one guest one time that said it's not enough even to say he probably did it. And to have testimony from their own expert that says, you know what, I don't know if it was an accident. I agree with you, Andell. I think that is that is troublesome for the prosecution. But I want to ask you, Imran, what do you think about the idea of this case having been perhaps overcharged, and whether or not, let's put aside murder for a minute, and if the prosecution asks for lesser included, which you would hope that they would given this case, what do you think about the manslaughter charge against Tex McIver? Do you think that the prosecution has that as a slam dunk? Have they focused on that enough? What are your thoughts?
Well, arguably it was overcharged, but we can expect that. When you're a prosecutor, you're going in and you're charging the top count and you're shooting for that top count, no pun intended, but often you will get the jury to convict on a lesser count. So in this case, when the intent is truly at question, right, the lesser included charges may be something that the prosecution may shift their argument and focus more on those. So in summation and hitting home their points and the evidence that they elicited during the trial, although you're always looking for a top count conviction when you're a prosecutor, especially when it's charged on the indictment. But sometimes it turns out that the evidence unfolds at trial and you're getting a lesser included. So I believe that they're going to be looking for those charges to be submitted to the jury. And if they don't prevail on the top count, the prosecution is going to be looking for the lesser included.
Andell, if you're defending this case, and now we know that the prosecution is getting to winding up, and now the defense has to put on their case, are you trying to sort of avoid the manslaughter stuff and avoid the fact that he was drinking a whole lot and avoid the fact that he shouldn't have been handling a gun while drinking and just hope the jury doesn't really get it? Or do you try to defend the manslaughter potential even though it hasn't been the focus?
I think you have to defend this case as far as just keeping the jury focused on your theory of defense. This was a tragic accident, nothing more. If we look at it from that perspective, I think it takes care of the manslaughter as well. We also have to look at not only the fact that Tex McIver was in the back of this vehicle, but the defense brought up he has a sleeping disorder that causes him to act out in certain ways that this is consistent with, and there has been recording of this disorder going on long before this trial was ever a thought. So I think they put up a lot of significant hurdles for the prosecution to overcome, even when it comes to the manslaughter charge. If you find that Tex McIver was acting reasonably as a person that suffers from that condition that the defense says he was in a dangerous neighborhood, and that this gun was on a setting where it was very sensitive, what they call the hair trigger setting, then this could be a reasonable mistake. It's an accident. It happens. Accidents happen. Not that we want them to happen, but we can't hold him to a higher standard than we would anyone else.
Yeah, and I do think that is going to be the defense in this case. What we've seen a lot from the prosecution is reconstructing the scene. They've done that with the seats in the car. They've done that with the guns. And they had an accident reconstructionist testify. We're going to watch a clip of that, and then I want to talk about whether the defense will use the same strategy or whether they'll go in a different direction. But first, the accident reconstructionist.
Double action, meaning hammer's not cocked, you pull the trigger, and as you pull the trigger, the hammer moves back until it finally releases. Single action, meaning you cock the hammer first and then pull the trigger. Sometimes, not every time, but sometimes the depth of the firing pin impression in the primer of the cartridge is different for single action versus double action. So what we can do is measure the depth of the firing pin impression in a fired cartridge case involved in a shooting. And then we can take a sample, take a particular firearm, fire it single action a certain number of times, fire it double action a certain number of times, and then look at the depths measured for each one of the samples and then see whether or not they're different. And if they're different, whether or not we can tell if the impression made by the incident cartridge, the one that was actually fired in the actual shooting, can be distinguished between one or the other based on that depth. So that was the test firing that I did the second time that I came out.
Okay. And can you tell the jury what were the results of that test if you did it?
What actually ended up happening is that the two different modes produced very similar depths.
State's Exhibit 285A. Again, can you take a look at this photograph, and if you could tell the jurors the position of the hands in this photograph, wherein the fingers are in a slightly downward position. Can you tell the jurors, is that hand position consistent or inconsistent with the analysis that you did in the vehicle with respect to trajectory?
It would be inconsistent.
All right, ladies and gentlemen, there you saw the accident reconstructionist, and the prosecution has done this consistently throughout the case. They've brought in things for the jury to see, for them to almost practically feel. They're going to go to the car itself. They're going to feel the gun itself. We often call that the dog and pony show, you know, where you get the jury the opportunity to see, touch, feel, smell, use as many of their senses as possible what actually happened in the case. Now, I want to start with you, Imran. Do you think that the defense will do something similar, or do you think that it's sort of done up by now and not really being all that effective with this jury?
Well, at this point, I think it would be wise, in my humble opinion, if the defense sort of boils this down to one concise argument. So throughout this trial, you see the prosecution really going at lengths to present any and all evidence to this jury. Now, again, we discussed that, of course, the people, the prosecution, have a huge burden. Got to prove the case beyond a reasonable doubt, and the defense will jump all over that if they don't meet that burden. So they've been doing everything. They've been bringing in experts. They've been showing, they're bringing the jury to the car. They're pulling out all the stops, and the judge is actually letting them do that. So the judge wants the jury to have a full picture. But the defense, if they want to sort of turn the table here, it may be wise if they just boil it down to keep it simple, stupid sort of argument. This was an accident. The evidence does not prove beyond a reasonable doubt that this was an intentional shooting. It was an accident, and that's all. So the defense may be better served in saying, okay, you've seen everything, the dog and pony show, as you say, but really what this comes down to is a simple defense, and the people have not proved their case.
Andell, one of the things the jurors brought up when they were last all together before spring break is, how long is the defense case going to be? If you're on the defense and you hear that question, do you work to streamline so that you are giving, you want to make sure, obviously, that the jury gets every single piece of evidence that you feel that they need, but to make sure that you're not making this any longer than it has to be, given the fact that the jurors seem to be sort of gnawing at the bit to get to the verdict?
Well, I don't think you would change your defense strategy all because of a comment from the jurors, but I think in general, you want to streamline your case. You want to make sure you're not making the jurors feel as if you're wasting their time going into things that aren't relevant to the case. I think the more concise you are, the more direct you are, and the more consistent you are with your theme and your theory of defense, the better representation you're going to give your client. So as a defense lawyer, you always want to be concise. You always want to be to the point, but you don't want to start messing with your strategy because of a question from a juror. Let's be honest. Most jurors could think of other things they'd rather be doing than sitting in a courtroom listening to us talk. We know that already. But what I find is that jurors, they take their job seriously, they're conscientious, and they're going to listen to the evidence. So my job is to present the evidence in a complete, clear, and absolutely a concise way so that we can get the best result for our client. In this case, you want to not guilty.
Yeah, it's going to be interesting to see what happens. We're going to take a quick commercial break. When we come back, we still have a lot to talk about. We have to talk about the Knight case. We're waiting for closings in that really interesting self-defense case that we've been covering. And we also want to talk about what we have coming up for you a little later this week, the David Copperfield case. I'm really excited about that one. So here's a quick commercial break, and we'll be right back. Welcome back to Law and Crime Network. I'm Heather Hansen, and we want to talk now about a case that we have coming up this week that's a little different than the cases that we cover as the norm here at the Law and Crime Network. This is a civil case. So the plaintiff in this case is a man named Gavin Cox, and he is suing David Copperfield and some other defendants because he was involved in one of David Copperfield's tricks. It was a trick called the Lucky 13, where they take 13 members of the audience onto the stage. those members of the audience then disappear or vanish and show up in a different part of the arena. And the trick is fabulous. However, in this case, Gavin Cox, during the time when he disappeared, fell and allegedly hit his head and alleges that he has some form of brain damage. And so he is now suing David Copperfield and these other defendants for that alleged negligence. Let's watch a little bit about that case, and then I want to talk to our guests about it.
World-famous illusionist David Copperfield might be forced to break the cardinal rule of magic and reveal the secrets of his illusions in open court. Copperfield is being sued in Las Vegas civil court by 57-year-old Gavin Cox, who claims he was injured during a 2013 Copperfield show in Las Vegas. The British tourist who once cooked for British royalty claims he fell and struck his head on the ground after tripping over construction debris as one of Copperfield's assistants whisked him and other audience members through a dark, secret passageway during the disappearing stunt. Cox claims he suffered brain trauma and is forced to wear an oxygen lung at night because he stops breathing when he's asleep. He's seeking punitive damages from Copperfield and MGM for alleged negligence. The illusionist and hotel strongly deny all claims, stating Cox's injuries were pre-existing and or unrelated medical conditions. This is Aaron Keller for the Law and Crime Network.
What an interesting case. I want to talk to you guys about it. And Andell, I want to start with you. You know, one of the things that I've heard people say about civil cases is that the attorneys for the injured parties look for damages first and then work backwards. Is it going to make a big difference just how damaged Gavin Cox actually is? If he looks to be sort of faking or just fine, do you think that that will have an impact on the jury from the very get-go?
Well, absolutely. And I think one of the things that just came out was whether these injuries are pre-existing.
Right.
Even if this happened the way that they said it happened, these injuries didn't come from this accident. They came from other unrelated medical issues. That's what the defense is fighting back saying. They're also saying that he had other accidents and he's trying to get paid from David Copperfield in his hotel over it. And I think that absolutely matters to the jury, whether or not these injuries, these damages came from this accident.
The other thing that's being alleged, Imran, is that there's punitive damages in this case, and that's something we haven't talked about a lot. So why don't you tell us just briefly what punitive damages are and why they might be pled a part of this case?
Sure. So punitive damages in a personal injury case where it's negligence alleged, it's going to be awarded when there's really gross negligence. So it's not negligence just per se, trip and fall, and there was an item which was left. It really has to arise to gross negligence, which is really an extreme form of negligence, unless, punitive damages are not necessarily awarded unless there's a showing on that behalf. So what I love about this trial is that you have two attorneys from New York who are trying a case in Las Vegas. You got a guy from Brooklyn for the plaintiff, and you got a guy from the Bronx for the defendant. So it's going to really make for some interesting theatrics in a city known for theatrics, Las Vegas.
Well, let's kind of pick that apart. First, I want to talk about the punitive case, and it has to be that the plaintiff has to prove recklessness. It's not enough just to say that they didn't do something right, that it was too dark. It has to be something that's reckless. And I think in this case, it's going to be interesting to see what the plaintiff is actually going to say was reckless in this case. It's not 100% clear. But to your point, Imran, it is fascinating to me. The players in this case are going to make this interesting viewing. Mark my words, ladies and gentlemen. This is going to be an interesting case to watch. First, you're going to have the attorney for the plaintiff. That's the person who's suing Copperfield. His name's Gavin Cox. His attorney's name is Morelli. I forget his first name here. I don't have it written down. But Benedict Morelli. Benedict Morelli is an extremely well-known attorney. He is sort of, for all of you trial watchers who so enjoy watching these cases, he is on the level of Jose Baez. He is that type of an attorney, very flamboyant, very aggressive, very argumentative. He, in fact, represented Tracy Morgan in the case that Tracy Morgan had when he was in that terrible accident against Walmart. So this attorney is someone who has done a lot of this type of work. I want to start with him, but then the defense attorney for Copperfield is also a well-known attorney. Morelli's from Brooklyn. The defense attorney's from the Bronx. His name is Theodore Blumberg, but he's a little bit more academic. So he graduated from Temple Law School. Morelli did not graduate from law school at all. He was able to take the bar through a different way of getting into the bar exam that's a little bit more convoluted. But Blumberg went to Temple Law School and has actually written one of the main books on legal writing. Andell, when we look at cases, oftentimes it's a battle of attorneys. What do you think about this battle?
Oh, this is definitely one that's interesting. We have, the street fighter, the scrapper out of Brooklyn versus the intellectual out of the BX, which is the Bronx. That's what we call it. But you know what? I have to say, the Bronx is kind of on a hot streak right now. Cardi B just dropped their album. The Yankees are doing great. So I don't know. We might have to give the edge to Blumberg.
Yeah, I just think it's going to be a really interesting case, from everything from watching the openings of these attorneys who definitely are not going to disappoint with their openings, and then seeing where the case plays out. It's also a case against MGM and the construction company, so parts of it may get into construction. It's going to be really fascinating to see how the case plays out and how these attorneys sort of differ in their approach. And most importantly, for any of you Magic fans out there, how many of David Copperfield's secrets are going to be exposed by this trial? And that's something that I'm sure David Copperfield is not all that excited about.
Well,
go ahead.
I'm sorry to interrupt. Actually, on that note, in the preliminary sort of discovery phase of this case, there was a sealing order from the judge, which was put in place on the request of the defendant, David Copperfield, to make sure that his proprietary information regarding his magic show and the secrets would not be in the public realm. So it's going to be interesting to see if that's going to also play out at trial.
Yeah, and I don't see how it can, because if the claim in the case has to do with negligence and even more than that, recklessness to elicit punitive damages, with respect to the trick, aren't we going to have to know exactly how the trick happened? This Lucky 13 trick has actually been documented in some of the articles about this case, but I would imagine that we'll have to hear Copperfield testify and that he will have to describe how this trick is done. The other thing that I think we'll hear from the defense is that this trick has been done for something like 15 years, over something like 100,000 times, and so perhaps it's just one of those things that is just purely an accident and not anyone's fault, and I'm sure that's going to be the defense. So we'll be watching that case. It's expected to start tomorrow, so keep your eyes and ears peeled for that. But today we have another interesting case that we've been following, and that's the case in Ohio against William Knight. And that courtroom is starting to bustle a little bit. We're waiting to see whether they start with the closings soon. We expect them to start with closings soon. And that case has been interesting as well, Andell, because initially the defense in that case was going to be an insanity defense on the behalf of Mr. Knight, who was going to claim insanity. But then after a competency hearing, that changed. Why do you think the defense made that decision?
Why they made the decision to change or to initially go with the insanity defense?
Well, both. Both. I mean, I think that they sort of feed into each other.
Right. I really don't know why they went down the route initially, but I would guess that it means that they thought that that was their best defense. They weren't too secure about trying the case on the merits of him defending himself. They thought the best thing to do would be to plead insanity. I really don't know what basis they had for that, because if we look at the evaluations where he was found competent, the defense stipulated the competency. They didn't fight it. They didn't have any experts or doctors that they could come back with to say that he was either incompetent or was in fact insane at the time of the alleged offense. So it seemed like a very weak defense at the time. And it may have been a diversion tactic to keep the state off their toes while they, explore this insanity defense. But really, they're coming back with defense of others, which ended up being their ultimate strategy.
Really good point, Andell. Guys, I want to take us right to the courtroom, because one of the things that happened this morning is the judge, we believe, is going to include manslaughter in that case. That's another case that may have been overcharged. The judge is back on the bench talking to the jury. So let's see exactly what she says about the charges that are going to be brought here. I want to thank you guys for being with me here this afternoon. Andell, Imran, I want to thank you guys for being with me here this afternoon, and we're going to take you right back to the courtroom. Welcome back to the Law and Crime Network, ladies and gentlemen. I'm Heather Hansen, and we just wanted to let you know exactly what's going on here. So the judge is instructing the jury on the law. To be honest with you, these instructions are often the most difficult part for a jury. We who work here went to law school for 3 years in order to learn this stuff, and yet still oftentimes struggle with it. And so to expect a lay jury to understand these legal concepts can be awfully challenging. The judge here is doing her best to explain things like direct evidence, circumstantial evidence, beyond a reasonable doubt in what that means, the evidence that they can consider, and to put things in context for this jury before they hear from the attorneys in their closing statements. I want to start with you, Andell. In your experience, do you feel as though jurors understand the charge, ignore the charge being the jury instructions, or do you think that they get enough of it to make it work?
If I had to guess, it'd be that they get enough of it to make it work. As you said, Heather, even us as attorneys, we always don't understand everything that's there. It's not always clear. And there's usually a good amount of debate between the parties about what their jury instructions are going to be. But as I said before, I think our jurors do a lot of work, and I think we underestimate them. They take the time to really try to understand the charges and what is being asked of them. And I think they use their common sense, they use the evidence, and they use their gut, and they make the decision.
Yeah, Andell, I couldn't agree with you more. I think we underestimate how much a jury pays attention to that charge and how much they want to rely upon it. Imran, have you seen situations where jurors come back with jury questions when they're out deliberating and they want to be reread a certain portion of that charge?
That happens all the time. The jury is out deliberating. There's a certain charge that they send a note back to the court. They want the judge to give a rereading of a specific jury charge. It's a very common occurrence. As a prosecutor, when they ask for the rereading of beyond a reasonable doubt, that sometimes sends shivers up your spine. And when you're a defense attorney, when they ask for a rereading of that charge, you're kind of giving a side glance and letting that sink with in the jury's head. So it's very often that the jury charge is lengthy. You sometimes see jurors, nodding off, unfortunately. But when jurors are really put to the test, they have to decide a case, especially a case involving something as serious as homicide. You see the jurors, when they need a readback of that charge, requesting it, and the judge gives that charge back to the jury.
Yeah, in some jurisdictions, they give the jurors a copy of the charge. That just makes sense to me. I don't understand why they don't do that in every jurisdiction. I think, well, why don't I ask you guys, the experts that I have here today. Andell, why do you think it is that it's not just the norm to give jurors a copy of the instructions rather than reading it to them and expecting them to process it and remember it?
I think that it would make a lot of sense, Heather, to make sure the jury has a copy of the jury instructions, because as you pointed out and Imran also talked about, they can be long and complicated. The best thing to do is have it right down in front of you on a piece of paper. Paper doesn't forget. They can go over it. They can look at the segments that apply to the case. If there's something they missed, they can go back and look at it. I think it would make a lot of sense, and I don't know why anyone wouldn't do it.
Yeah, it seems to me that it would certainly be helpful to our jurors. We're going to take you back to listen to some more of these instructions. I know, Andell, you have to leave us shortly, so this might be our last time to see you. We're not sure, but if so, thank you as always for being with us, and I'm sure we'll see you again soon. Imran's sticking around with me for a little bit longer, so I'm not going to say goodbye to him just yet, but we're going to take you back to the courtroom as the judge continues to instruct the jury on the law.